Well, good afternoon, ladies and gentlemen, and welcome to this Hughes Hall Centre Biomedical Science and Society seminar. This is a termly event, but just before we get going, I thought I should explain to those of you who don't know that this seminar is organised, as the name suggests, by the Hughes Hall Centre Biomedical Science and Society. That's a centre which is based here in Hughes Hall, with generous funding from a PhD foundation, which aims to study issues which arise in the translation of biomedical research into interventions aimed at population and individual health. So specifically it looks at these issues from social scientific, legal and philosophical angles, and so unsurprisingly it employs a philosopher, myself, Stephen John, a lawyer, Dr. Anish Pandit, and a social scientist, Dr. Vastanchi. We have been running a termly seminar series where we have extremely distinguished speakers come to talk. I should say before we go any further that we should be extremely grateful to Jenny and to Hannah in the development office for making all of this work so well. And we've had extremely interesting seminars so far with extremely provocative speakers from philosophy, law and social sciences. But our speaker tonight is Professor John Spencer. Professor Spencer may be well known to many of you. He's a professor of law here at the University of Cambridge, where he's also a fellow at Selwyn. His interests include criminal law, evidence law, comparative criminal law, and tort. And it also tells me he's a QC, an academic bencher of the Inner Temple, and holds an honorary degree from the University of Poitiers. Professor Spencer is a frequent speaker on the radio, precisely because he's extremely entertaining, erudite, and witty. So, having set him up, it's now his turn to make good on his promise. Thank you.
After that kind introduction, how can I other than disappoint? Thank you very much. Can everybody hear me all right if I speak at this pitch through this microphone about this speed? Yes? I chose this title, Prosecuting Medical Professionals, as the doctors say there's a lot of it about, because I was stimulated to do so by three news items that came my way. The first was a lecture given in the law faculty last year by my academic colleague Oliver Quick, Medicine, Mistakes and Manslaughter, in which he talked at some length and in detail about the prosecution of medical professionals for gross negligence manslaughter, and you'll see he said that it's on the increase. To the best of my knowledge, he said since 1925, 65 health professionals have been charged with medical manslaughter, with over 50 of these since 1990. And then there was the other day, the scandals in the newspapers all about Dr. Ubani, the German doctor of Nigerian origin, I think, who came to do out-of-hours treatment in East Anglia under some, frankly, cockeyed arrangement which the National Health Service has, and accidentally bumped off one of his patients. And you'll see, put out-of-hours killer on trial, say victim's family, after Euro loophole spares blundering German doctor. And there are other news items, probably all the print too small for you to see, about families demanding the prosecution of this doctor. There's some more, but they all say the same thing. And then the third thing was something about which Ron Zimmern organised a seminar when it was still a bill, the Human Tissue Act 2004, which, as I'm sure you know, sets up this complicated regulatory scheme for governing the storage and use of bits of dead people, following the scandal about the retention of mainly dead children's organs at that hospital and the great upset to their parents when it was discovered. And this act really waves the big stick, dealing with body parts without appropriate consent, 3 years jail, unlimited fine, or both. I won't read that 3 years unlimited fine or both out bit because it comes up on every one. Doing things without a license to body parts that require one. Possession of anatomical specimens away from licensed premises. possession of foreign anatomical specimens away from licensed premises, commercial dealings in human material for transplantation. As they say in Private Eye, Kant, page 94. There's quite a bit more where that came from. And that set me thinking about the question, when does the law impose criminal liability on medical professionals? When should it? This lecture I've prepared is aimed at a general audience rather than an audience of lawyers, and I'm slightly overawed to see so many distinguished lawyers in the audience. I hope they won't be too bored by what I say, because it will be from the perspective of somebody who knows about the law really a bit jeju. I looked that up once, and it's something to do with fasting and empty stomachs. I think that you eat it and you still feel hungry at the end. Well, I'd like to start by examining critically, first of all, manslaughter by gross negligence, the criminal offence for which allegedly negligent medical professionals are sometimes prosecuted, and the one that a lot of people in East Anglia thought Dr. Ubani should have been prosecuted for. It's part of the general law. It's not just health professionals who can be prosecuted for gross negligence manslaughter. Anybody can if they grossly negligently kill somebody. You may have seen that case in the papers a couple of years ago about the father who gave a quad bike to his daughter and then let her follow his 4x4 down an unlit country lane. What was she, 7, 8, something like that, and she got killed, and he pled guilty to manslaughter, and so on. But in principle, of course, medical professionals can't expect to be exempt from any part of the general law, and it's not surprising, therefore, that medical professionals, like others, are liable to be prosecuted for gross negligence manslaughter when allegedly it's their gross negligence that caused the death. But does gross negligence manslaughter bear more heavily on medical professionals than on other groups? When I was preparing this lecture, I started off thinking, no, it doesn't. But then I thought about it a little longer, and I think, on reflection, it probably does. The first thing is that in practice, by reason of the nature of their work, medical professionals are dealing with lives at risk, and when things go wrong, people are particularly likely to die, and that puts them in the firing line for prosecutions for gross negligence manslaughter. And as the criminal lawyers among us will know, nearly all the leading cases in the criminal law textbooks about the definition of gross negligence manslaughter are cases that involve the prosecution of medical professionals. The leading case of all is Bateman in 1925, which was a doctor who was prosecuted for manslaughter following the death in breech birth of a woman whose delivery he allegedly bungled. There's Prentice, who managed to inject the wrong thing into somebody and caused their long and painful death. There's Dr. Adamarco, the anaesthetist in a not very well-run hospital where a patient was wired up to what they called in Monty Python, The Meaning of Life, the machine that goes ping. You remember that initial scene? And the machine started to go ping, and he naturally assumed it was the machine that had gone wrong rather than the patient, so he tried to mend the machine, and meanwhile the patient died. And then there was Misra, a case where Misra and another doctor were prosecuted when they failed to notice that one of their patients was extremely ill with infection, which eventually produced toxic shock, and when it was alleged any competent doctor would have noticed what was happening and intervened to get some further treatment for them. So in practice it bears rather heavily upon them, and secondly, according to some, it's not really very fair that it should bear upon them so heavily, particularly given the moral landscape in which it operates. Doctors, unlike drivers or employers, are actually trying to keep alive the people who they accidentally kill. A lot of people think it's a bit much that you should be not merely suing, but actually prosecuting the hand that tries to save you. Secondly, is manslaughter by gross negligence, as it's defined at the moment, a satisfactory offence? Most people say that it isn't a satisfactory offence because the content of the offence is so extremely vague. That's the famous Bateman test, the test laid down by Lord Chief Justice Hewitt about what makes negligence bad enough to be gross negligence, thereby justifying a prosecution, as against simple negligence, simply justifying a lawsuit for damages. In order to establish criminal liability, the facts must be such that, in the opinion of the jury, the negligence of the accused went beyond a mere matter of compensation between subjects and showed such disregard for the life and safety of others as to amount to a crime against the state and conduct deserving punishment. That's criticised because it's circular. It's a direction to the jury, the tribunal of fact. Members of the jury, if you think it's bad enough to deserve punishment, then it falls within the legal definition of gross manslaughter. Handing over to the tribunal of fact, so the critics of this test say what should actually be a matter of a firm test existing as a matter of law. And so you never know what is going to be the result. And the Bateman test was reaffirmed in Adamarco, the House of Lords case, a number of years ago, about 15 years ago. And there was an attempt to argue afterwards that with the Human Rights Act and Article 7 of the European Convention, which bans ex post facto criminalisation and requires a degree of certainty in the criminal law, that this test failed the requirements of sufficient certainty in a country devoted to the rule of law. That argument was put forward in Misra, but it failed and leave to appeal further wasn't given. But a number of people feel that it is too uncertain to have as a legal test of criminal liability, and effectively means there can be random, inconsistent results depending on the general impression that the tribunal of fact, jury, jury, happened to have of how nice the defendant was and how nice the victim was. Let's go back to basics and consider whether in principle there should be such an offence as gross negligence manslaughter. That raises the initial question, should the criminal law punish negligence at all? I suppose everybody accepts that the criminal law rightly punishes negligent behaviour at a low level when only minor punishments are to be imposed and when it's going to be prosecuted at the level of the magistrates' courts with somebody ending up with a fine. But should the criminal law, the bit that creates serious criminal offences, ever base criminal liability for an offence which is potentially punishable with life imprisonment on negligence rather than intention? There was an argument among traditional criminal law writers for many years that the central part of the criminal law should only punish behaviour which was intentional or subjectively reckless, that's to say, done with your eyes open rather than simply negligent, and that the criminal law proper just doesn't have a place in punishing negligence. It's not right that it should do so. Why? Well, the first branch of the argument was the criminal law is about deterring people from undesirable behaviour. How can you can deter people from acting intentionally by reminding them that something bad will happen if they take a decision to do this, that or the other. And you can similarly deter people from acting recklessly when they foresee the consequences. But people who are negligent just haven't thought, and how can the criminal law deter people from acting thoughtlessly? If you take the view that punishment is an evil and it should only be imposed for some valid purpose, there's no valid purpose in punishing people who are negligent, even grossly negligent, because it doesn't lead to the deterrence of similar behaviour. And the second branch of the argument was, anyway, it's unfair to punish people who are doing their incompetent best. They did their best. You shouldn't punish them for it, should you? But way back in the 1960s, the legal philosopher Herbert Hart answered both of those arguments. Herbert Hart said that in the case of punishing negligent behaviour, the threat of punishment is something which causes him, the citizen, to exert his faculties rather than something which enters as a reason for conforming to the law. It is perhaps more like a goad than a guide. The knowledge that you could be prosecuted if you're careless in the way you do it presumably operates at least to some level to encourage people to take care about what they do. So it doesn't fail any utilitarian criterion of punishment to have criminal offences directed to negligence. And he went on to say it's not unfair to punish people for negligence if they were doing less than their best. If they were negligent in the sense of they could have done better, then that's a moral fault, and it's justifiable to punish people who are morally at fault. Of course, negligence isn't as bad in the hierarchy of moral ills as intentionally hurting people, but nevertheless, in extreme cases, it's something which is properly punished by the criminal law, at least sometimes. And I think the consensus view among legal theorists nowadays is, yes, criminal liability for negligently harming other people is justified in certain contexts. I learnt my criminal law from the first edition of Smith and Hogan's textbook, which came out in 1965, and that passage continues to appear in the current edition, which some of you may use. The negligent handling of certain instruments, notably motor vehicles and firearms, can have such drastic consequences that society is almost bound to adopt any measures which seem to have a reasonable prospect of inducing greater care. For this reason, if for no other, it's thought that manslaughter by gross negligence, as well as some statutory crimes of negligence, may be justified. So yes, there is probably, well, I think certainly, a justification for imposing, in principle, criminal liability for grossly negligent behaviour that harms others. Furthermore, the law in most other countries, certainly those in continental Europe, imposes also criminal liability on those who negligently cause death. The law of France does. There's an article of the French Code Pénal which imposes criminal liability for negligent homicide. Causing the death of another person by clumsiness, rashness, inattention, negligence, or breach of an obligation of safety or prudence imposed by statute or regulations, blah, 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 constitutes manslaughter punished by 3 years imprisonment and a fine of 45,000 euros. I think it was some more sensible sum initially when it was francs, and that was the conversion rate when the euro came along. May not be with us for long, may it now? And then it goes up a bit if there'd been a deliberate violation of an obligation of safety or prudence. And actually, French law on the subject is more severe than English law to the extent that it bases criminal liability on simple negligence, not gross negligence. You incur criminal liability under the first sentences of that provision if you fail the standard of ordinary negligence. It simply ups the penalty if you are grossly negligent. What's more, look a little later at Article 22119 and you'll see there's a criminal offence in the French Criminal Code of negligently causing injury. So it goes beyond English criminal law, which simply punishes negligently killing people and doesn't punish negligently injuring people, which is a matter simply of compensation of the civil courts. And you could say that French law is more severe than English law on the subject for two reasons. Liability for simple negligence, and in addition to that, there's also liability for negligently causing personal injury. What's more, you find provisions like that in the criminal codes of all the continental countries. I believe certainly in the criminal codes of Germany, of the Netherlands and Italy, and that's as far as I've got to look, but I suspect you'll find them in others as well. So in reality, is English law more favourable to medical professionals than in other countries around? Well, no, not altogether. It's actually significantly out of line and more severe, first of all, because of the level of punishments that we impose. The maximum penalty for manslaughter by gross negligence, like any other form of manslaughter, is life imprisonment, theoretically, whereas, as you saw a minute ago, the maximum penalty for negligent manslaughter in France is 3 years, sometimes rising to 5. Secondly, if you look at what actually happens in France, when medical professionals, and indeed many other forms of negligent people, get convicted of negligent homicide, the court solemnly imposes a prison sentence, but routinely suspends it. You get suspended sentences almost always, and I'm unaware of any case in France where a simply negligent doctor actually felt the clang of the prison gates behind him. A fine and a suspended sentence seems to be what's normally imposed. Whereas, typically, if somebody gets a conviction for gross negligence manslaughter in this country, he will get an immediate jail sentence. He will actually go to prison. So how, in an ideal world, would we change for the better criminal liability for gross negligent manslaughter, generally, and with particular reference to medical professionals? Well, I think we could much improve the definition of gross negligence. Some of you may have read that excellent book, Errors, Medicine and the Law, by Marion McCall Smith. McCall Smith has shot to public fame as a best-selling novelist, the Ladies Detective Agency series. But before that, he was extremely well respected as an academic, a writer about medical law matters, and he wrote that very good book, together with a practitioner, examining the concept of fault and when fault should be punished in the context of medical mishaps. And they said we should draw a distinction between violations and simple slips or lapses. What makes gross negligence really bad is the case where the professional of whatever sort has broken a rule with his eyes open. He may not have foreseen the consequences, but he's broken a rule with his eyes open. The anaesthetist, for example, knowing that the first rule of anaesthesia is that you stay with the patient, nipped out for a smoke or to telephone his girlfriend, leaving the patient unattended. Or the surgeon who actually turns up drunk to do the operation. And similarly, throughout all walks of life, it's a worse form of negligence when you've broken a rule, knowing you've broken a rule, even if you didn't foresee the damage that would result. And that's reflected in that article in the French Criminal Code we were looking at, when you saw that the punishment for negligent homicide goes up in French law if it involved the conscious breach of a rule. And if I were dictator of England, rewriting the criminal law, I would rewrite gross negligence manslaughter around the Marion McCall Smith notion of limiting it to cases where there's been a conscious breach of a known rule. The second thing I would do is to reduce the maximum penalty. Of course, normally people convicted of gross negligence manslaughter don't get sentences of life imprisonment. By convention and according to guidance laid down by the Sentencing Guidelines Council, they probably only get a couple of years at the most. But even so, it would be sensible if, as in France and other countries with criminal codes, we had a maximum penalty for gross negligence manslaughter that was different from the mandatory penalty for murder. We should have a maximum penalty of 3 years or 5 years or something for gross negligence manslaughter. And thirdly, wouldn't it be wonderful if only we could accept that people haven't walked free when they've got something other than an immediate jail sentence? Wouldn't it be much better if we could accept that suspended sentences in cases like this are generally appropriate rather than only exceptionally to be imposed? Well, that's what I would like to see happen, but frankly it seems unlikely to happen because the increase in prosecuting medical professionals for manslaughter must be read against a current trend, which is to expand criminal liability for negligent homicide in all directions. We used to have simply manslaughter by gross negligence, but look what we've acquired over the years. Causing death by dangerous driving, punishment now up to 14 years. Causing death by careless driving when intoxicated, 14 years. Causing death by aggravated TWOC, aggravated vehicle taking, 14 years. Negligently failing to prevent a vulnerable family member from getting killed, 14 years. Corporate manslaughter in 2007, limitless fines. And now causing death by driving when uninsured, etc. And causing death by simply careless driving. Causing death by careless driving, I think it's 5 years. I put 10 years, please ignore what I put on the board there. What's the reason for this? Well, it's what Tony Bottoms, our former professor of criminology, here described in a well-known article as popular punitivism. Agitation reflected in the popular press for punishing people who do this, punishing people who do that. The Cambridge Evening News took a key part in causing the introduction of an offence of causing death by careless driving by Murray Morse, its former editor's Killer Drivers campaign, which consisted of giving huge publicity to every case where somebody had caused a fatal accident on the roads and they didn't go to prison, complete with interviews with the weeping relatives and how my life's been ruined now and how it's not fair and how I have to live with this forever and how he's only been fined and so on and so forth. And there's Murray Morse handing his petition in to the minister. I haven't got it to show you on the screen, but the minister gave a Mickey-mouthed statement saying how most grateful she was to Mr. Morse for bringing this to their attention. And of course, we will immediately cause legislation to be done about it, and causing death by careless driving was the result. And the penalties were extremely severe, I think, in relation to the degree of moral fault applicable. The first case that reached the Court of Appeal on the appropriate sentence for causing death by careless driving involved a Mrs. Lark, aged 74, or maybe only 73 when it happened, who led a blameless life in which she devoted herself to the care of the disabled, and she drove her dog to the country to let it run in a field, and when driving out of the lay-by where she parked, she didn't look properly and drove into the path of an oncoming motorcycle going at high speed, as a result of which it swerved and tragically threw off the driver and the pillion passenger, both of whom were killed. And she was sentenced to 2 years immediate imprisonment. And because jail sentences in this country take immediate effect and aren't normally suspended pending appeal, off she went to Holloway, pending it going to the Court of Appeal, where I'm pleased to say the Court of Appeal, in a merciful mood, managed to substitute 39 weeks imprisonment suspended for a period of 12 months. But that shows the degree of severity when it is thought appropriate, at least in some cases, to punish people when there have been negligent homicides. One of the leading cases on causing death by dangerous driving, which has been around longer, involved a bus driver, a Mr. Topasna, who had this coach which was taking a group of people somewhere, and he was an automatic, and he somehow managed to press his foot on the drive pedal when he meant to press it on the other pedal, and it went off on, as he was frozen in panic at the wheel, on what I'm sure the local paper called a horror trail, in the course of which, alas, 5 people got killed. 5 years imprisonment, 1 year for each person killed. But what had he done? He accidentally made a mistake and he'd frozen in panic. It seems most severe, despite the deaths of all those people, to send somebody to 5 years immediate imprisonment in those circumstances. What's the explanation for this explosion of desire to punish severely those who've caused death by carelessness? Well, I think there are a number of explanations. I think it's partly displacement. I think it's a desire to transfer to individuals the anger, or apply and direct to individuals the anger and unease we feel about other and bigger problems in society that we can't control. Frankly, I think we made a bad mistake when we repealed the Red Flag Act in 1897, wasn't it? The Act of Parliament, which said that any automotive vehicle had to be preceded by somebody carrying a red flag in front of it. Motor cars are extremely dangerous, and by allowing motor cars to drive on the road, we've created a situation in which inevitably people are going to be killed, and we're worried about it, and we take it out on the occasional individuals who, doing what any of us behind a wheel might do sometimes, that's to say, making a careless mistake, accidentally kill people. Concerns about health and safety seem to me to be partly motivated by broader unease about bigger environmental concerns. And I think this desire to prosecute individual doctors when things have gone wrong, or picking on the individual doctor to some extent to blame him for what is, if I may put it crudely, a crap system. Dr. Adamarko, according to one of the commentators on the case, trained in Russia, and though at the time in question he was in his late 40s, his career had consisted entirely of 6-month contracts. He was working in the week at one hospital and during the weekends at another. On the morning in question he'd started work at 7 o'clock, having gone to bed only 3.5 hours earlier, and at the time of the incident he did not have the system he was supposed to have. To use a cliche, that was an accident waiting to happen. The system was deplorable, just like the system was deplorable that allowed Dr. Ubani to come over here when he could barely speak English and killed somebody with a drug he was unfamiliar with. In 2006, the Health and Safety Executive successfully prosecuted Southampton NHS Trust for an offence under Section 3 of the Health and Safety at Work Act for not adequately supervising Doctors Misra and Srivastava, the people who were prosecuted for manslaughter I mentioned earlier. And it's better to prosecute them. But in the end, what's behind this is cut price systems resulting from the dishonest failure of our politicians to tell us that sufficient money must be gained by taxation to pay for proper systems. Every day they say, we won't put your taxes up, we will cut waste. However many billion is it Mr. Cameron's going to cut waste? What it means is inventing daft ideas like the arrangement under which Dr. Ubani came over and accidentally killed a patient. We should be prosecuting our politicians for gross negligence manslaughter, I think, not our health service trusts. I think another feature of it is a sort of atavism. In the early Middle Ages, and of course before, liability for causing death was strict. If you'd caused somebody's death, then you were liable to retribution, however you'd caused it. That was the law of the ancient Germanic tribes who spread across northern Europe And it was reflected in the early English common law and in the law of France and in the early law of Germany. And as Maitland said in his legal history, describing the situation in the 13th century, the man who commits homicide by misadventure or in self-defense deserves but needs a pardon. He's basically guilty unless the king pardons him. And it was the same in France. And we took it further. We had the institution of the deodand, under which the instrument that had caused death was noxally surrendered and sold off. The bull that had gored somebody had to be surrendered to the state. I think probably to be killed initially, but latterly to be sold off. And something that continued with us in English law until trains came along and railway companies got very worried about old trains being seized and the law got quickly changed. And the notion that because somebody's been killed, there must be retribution was gradually driven out of the criminal law under the civilizing influence of the Christian Church and the doctrines of the Roman lawyers. But it seems to me the underlying feeling is still there, and it's reflected in the reaction in newspapers like the Cambridge Evening News when there's an outcry because somebody's been killed and nobody's been sent to prison. And for years our politicians would have stood up to that sort of public outcry, but now they're swimming with the tide, and we're going to end up with criminal liability, criminal law, under which if you kill somebody, you're strictly liable for the death and probably get a mandatory jail sentence before we know where we are. And then the third aspect of the matter is what Martin Neri the other day, a civil servant in charge of prisons, but now converted to good causes and running Dr. Bernardo's, described as the nation's love affair with custody. Here's what he said. No serious discussion about penal policy is now possible because in this country we have a love affair with custody. I'm not critical of politicians. Well, I am actually, because it is their life, it's their party's electoral success. All the Home Secretaries have been entirely convinced by the intellectual arguments, but they say it's impossible for them to go and do. Cutting prison numbers would be political suicide. Of course, part of me thinks they should just take on the press. All of me thinks that. But it would need courageous behaviour. Lord Phillips, formerly Lord Chief Justice, now Senior Law Lord, made a courageous attempt to try to persuade the public that something was significant as a penalty other than immediate jail sentence, when he actually impersonated a convicted person and smuggled himself into a group doing what was called community service that week. I can't remember what the horrible name for it is now. And then told everybody actually it was jolly hard work. But unfortunately, if anybody gets anything other than an immediate jail sentence, if it means he's liberated because the jail sentence he's given happens to be the same as the period he spent in time on remand, if he's given a suspended sentence, if he's given a huge community service order, it's reported in the paper, walks free. It's mercifully different in France. The French always seem to have a different attitude. I beguiled a long plane flight once by reading a book about the history of French criminal law, and I discovered a most interesting fact. Under the Ancien Régime, French law was tremendously ferocious, but it didn't actually catch many people because France was all divided up into different bits and jurisdiction was not general. And so what you often had was condemnations in absentia followed by executions in effigy. And the public would turn up and be delighted at seeing this person hanged in effigy or burnt in effigy or broken on the wheel in effigy, and everybody went home happy. And that seems to be continued into the French mentality with their general acceptation of suspended sentences being fine. You know, the principle's been upheld, he's had a prison sentence, but not really. It's all sort of imaginary and everybody's happy with it. Well, so much for manslaughter and its application to medical professionals. Now a few words about the last thing that we got to. Yes. The Human Tissue Act 2004, which creates all these criminal offences, which I mentioned to you about doing this, that or the other with bits of dead bodies. It's part of the specific law rather than part of the general law. It's part of the specific law that applies to all sorts of, to medicine and pharmacy and everything in general. A whole range of specific offences exist, like in this area, like selling medical practices. Did you notice that a medical practice was now a criminal offence, punishable with the fine of the profit you made plus £500 or 3 months in prison? Not labelling medicines properly, contravention of the misuse of drugs regulations, for example, by issuing a prescription for a controlled drug which is, quotes, not written so as to be legible, advertising cures for cancer, claiming to be a doctor when you've been struck off, claiming to be a dentist when you've struck off, etc., etc. And on the face of it, the Human Tissue Act is part of a common and sensible enough arrangement. Parliament creates a regulatory scheme because it's perceived that something needs to be regulated, and the regulatory scheme contains you must and you mustn't, and then there have to be some teeth in the you must and you mustn't, and teeth is given by creating criminal sanctions. So it's not obviously unreasonable to have all these prohibitions and requirements in the Human Tissue Act then subject to criminal liability when you've broken them. But first, are criminal sanctions always appropriate? And are they in particular appropriate in this context? Criminal law surely should be the ultima ratio, the thing that society uses against something when there's no alternative. But unfortunately, and so we should think, maybe, before we create these criminal offences, whether there could be a sanction in the form of an administrative fine, or a sanction in the form of being struck off by the GMC, or something else other than prosecution in the criminal courts. And it's not always obvious that prosecution is the sensible way to enforce these schemes. Unfortunately, criminal law these days is not considered anymore as the ultima ratio. Successive governments, and in particular the present one, which is, at least I suppose this present one until sometime later on tonight, the prima ratio, the initial reflex reaction of the government when it wants to do something about something. We have had a mass of criminalisation in recent years. The figure much put around is 3,500 new criminal offences since Tony Blair won the 1997 election. That's a slight exaggeration because a number of them are recyclings of earlier offences, but we've had a huge number of new criminal offences. To the point where Private Eye satirised the matter of that. I don't know whether you can read it. In response to concerns in the paper about binge drinking and claims there should be something done about it, Britain faces an epidemic of round-the-clock lawmaking which threatens to plunge the country into a new dark age. Evidence is mounting to show the government's policy of 24-hour lawmaking is producing nothing but confusion and chaos in the streets of all our major cities. Citizens no longer have any idea of what is or is not legal, and many, it is clear, are so bemused they no longer even know which country they're living in. Only too typical scene of life in Britain today was witnessed by shocked observers recently in the heart of London's once respectable Westminster. Groups of middle-aged men and women could be seen sprawling about on green leather benches in an all-night session of reckless lawmaking. I've never seen anything like it, said one horrified New Zealand tourist. These people were totally out of control, spewing out law after law. It was sickening. We say this, it's time this shameful man was established. Once for all, there ought to be a law against him. And resulting in the sort of situation where Banks drew that cartoon, those two glum policemen, and if you can't read it, one of them saying to the other, typically British, isn't it, a police state without enough prisons? Much of the criminal legislation that we have, many people believe to be futile. I don't know whether you like that offence. A person who knowingly causes a nuclear explosion is guilty of an offence. Well, That's going to put the frighteners under Osama bin Laden, isn't it? My God, prosecuted in the Crown Court. Quite a lot of it has absurd penalties. Clamping cars. Now, putting a clamp on a car is now illegal unless you have a license from the clamping quango, and you have to have a course in how to clamp cars healthily, safely and non-discriminatorily. And do you know what the maximum penalty is for clamping a car when you don't have a certificate? 5 years imprisonment. Much of the criminal law that gets enacted is enacted in the certain knowledge it's not going to be applied. One of my bugbears is the Sexual Offences Act 2003, which was supposed to modernise the law on sexual offences, and in the process reinforced the rule that sexual acts with minors are all criminal, even sexual acts between consenting minors themselves. And it was pointed out that this was stupid, and the government said, oh no it isn't, we mustn't leave any loopholes for paedophiles, there's a discretion to prosecute. Apparently if 19 out of 20 or 99 out of 100 cases are not going to be prosecuted, you still have to send a signal by having the law as dialogue rather than an instrument actually to enforce. What's the reason for this? Well, the reason for it is partly that the government is terrorised by the tabloids, I think. There's a diagram I've got one of my students to put on the screen. I don't know whether you can read that. To sell papers, tabloids hype crime. Fear of crime grows. Press hypes fear of crime and demands action. Politicians scared of tabloids promise tough measures. Politicians use war on crime rhetoric to win support for tough measures. And tough measures, of course, promote yet more fear of crime, and so it goes round. And it's also because those who make the criminal law, unfortunately, have no intelligible philosophy, as far as I can see, about what the proper place of the criminal law is. It seems to me it undermines the rule of law to have too many offences widely disregarded. It breeds contempt for the rule of law to have a lot of offences which aren't actually enforced. When I explained to our younger daughter, then still in her teens, that the new Sexual Offences Act was going to make it a criminal offence for two people aged 15 to kiss mouth to mouth, her words were, "Dad, you're taking the piss." And then more seriously she said, how can you expect people to respect the law if it makes offences out of stupid things like that? I wish we could change the attitude of our politicians in respect to wanting to criminalise everything at any indication from the tabloid newspapers, and stop them having an attitude of thinking that to criminalise it is to appear to do something sensible about it, whatever the problem might happen to be. Is there any sign of such a change? Well, my older daughter, who is a civil servant and actually reads political party manifestos, drew my attention to that. It was actually in the Lib Dem manifesto. One of the things they say they'll do is halt the unnecessary creation of new offences, and help the increase in unnecessary new offences with the creation of a stop unit in the Cabinet Office. Every department in Whitehall would have to convince this unit of the need for new offence. Well, it was a very small paragraph, I have to say. It is a small party. But it's one of the reasons why I got up at 7 and cast my vote for them this morning. Thank you, everybody, for your attention. I now stand down and invite Amit to respond.
I'd like to say thank you to Professor Spencer for a talk which was as entertaining and informative as I promised you. so I feel good as well. There will now be a response to a talk by Dr. Amit Kundik. Amit is a lecturer here in the Hughes Hall Centre for Biomedical Science and Society, working on issues to do about the evidence law, use of statistics in the law, issues about causation and responsibility, and so on. And then after Amit gives his response, the floor will be open for people to ask questions and make comments to Professor Spencer.
Right. It is election day today, and although I'm not allowed to vote in this country, I consider myself nevertheless fortunate that at least I don't have to stand here and defend this government's policies from Professor Spencer's illuminating and thorough critique of recent development in this field of law. I do think, however, that it is important to distinguish between two questions with regard to the potential liability in criminal law of doctors and other medical professions. The first question is a question of principle. Should criminal law be used to regulate the field of medicine and public health? More generally, should the law interfere at all with the work of medical professionals, and if so, what is the best way to do so? What goals should the law aim to achieve, and what type of legal liability is most appropriate to achieve these goals? The second question is a question of implementation. If criminal liability should indeed be part of legal regulation of medicine and public health, what offences should be recognized? How should these offences be formulated, and what legal tests should be used? What level of punishment should be imposed? These two questions are of course intertwined, and it is probably not possible to answer one without assuming something about the answer to the second one. However, when discussing criticism of current legal policies, it is important to identify at which question the criticism is aimed. I should say at the outset that I do not intend to defend the current policies on the level of implementation. Perhaps there are better ways, to phrase the relevant legislation more accurately, identify the applicable offences more clearly, and construct the relevant legal tests to be more helpful than they currently are. Professor Spencer's presentation surely gives us several good reasons why such reforms are necessary, for example, reducing the level or the gravity of punishment. Yet I would like to engage with his presentation on the level of principle. Is it appropriate to use criminal law to regulate the medical profession? To stir up discussion, I'm going to take the rather unpopular stance, and I would like to offer some considerations in favor of the expansion of criminal liability on doctors. Now, the legal liability of medical professionals today consists mainly of tort, that is, civil actions against doctors. When a tort claim is successful, it doesn't lead to any direct sanctions on the doctor herself, but only to a compensation for the patient. These proceedings are sometimes followed by other types of proceedings, usually regulatory proceeding by the GMC, the General Medical Council, but many are not followed by any other proceedings. Although we have just heard the number of criminal prosecutions is on the rise, the number remains negligible when compared to the number of tort claims made for clinical negligence, which last year amounted to over 5,000 new claims and over 10,000 outstanding claims, according to the NHS Litigation Authority. The current system seems desperate for reform. First, it's hugely expensive, and costs are constantly increasing. The estimated annual cost of a compensation in 1975 was 1 million, which is more or less 6.33 million in today's values. Last year, the cost of compensation was over 769 million pounds. Secondly, the current system suffers from high administrative costs, so that most of the money that comes in spent on lawyers, insurers, and administrators rather than on actual compensations of victims. By 1988, for example, administrative costs have reached almost 80% of overall cost of the system. To these problems can be added fears of defensive medicines and concerns about the effectiveness of tort system in improving the level of care patients actually receive. So, reform seems highly desirable. Now, we should distinguish between two directions in which reform could lead. The more trendy direction is toward less emphasis on the element of fault in the behavior of the relevant medical professionals. So, to that in the extreme, there are calls even for the abolition of most types of legal liability for legal professionals, for medical professionals, with the exceptions of some very extreme cases of intended harm. Some of you might be aware of the doctor saying that the only appropriate place for lawyers in the public health system is on the operating table. It is doubtful, however, whether such radical reform is desirable. The GMC seems quite reluctant to impose serious sanctions on its member. In 2004, which is the last time the GMC made this information available, out of approximately 5,000 formal complaints, fewer than 1% resulted in suspension or erasure. It is worth remembering that whenever a group of professionals of profession is left to regulate itself, it seems to do a brilliant job of securing its own interests, but less a brilliant job of taking care of those needing the service. If you would like a recent example, just think about bankers. A more serious alternative is the no-fault regime, where victims of unexpected adverse outcome of medical treatment receive compensations regardless of whether the professional who treated them was negligent or not. Such a system is deployed most famously in New Zealand and Sweden, though there are some specific areas in the US and the UK which are regulated by a similar system. So, for example, the vaccinate damage scheme is a good example. Under this system, admittedly, a much higher proportion of the money spent actually going to the victims, probably between 85 to 93%, comparing to the meager 20% of the existing system. However, no-fault systems are very expensive to maintain. The expansion of compensation to cases where the doctors were not negligent at all, together with the increased efficiency of the administration, which no longer needs to assess complex questions of fault, leads to a significant increase in cost. The Chief Medical Officer estimated in 2003 that the cost of implementing such a system in the UK would be between £1.6 billion to £4 billion. That is between 4 to 10 times higher than what the existing tort system cost when the estimate was made. Now, the obvious question here is whether this is the best place to invest such eye-popping sums of money. Wouldn't it be better to use the extra few £billion to provide better medical care, rather than cash compensation to those suffering adverse conditions, which may or may not have resulted from any fault? No less importantly, there is a point about distributive justice here. These compensations give those who suffered from adverse outcomes something more above the level of social protection that each person receives. What is the justification for such a differential treatment? Why does someone who was unlucky enough to suffer from rare adverse outcome of a particular medical treatment deserve this extra compensation, while another person who is unlucky enough to suffer from a rare disease gets nothing on top of the whatever he gets? Instead of putting so much weight on the question of how the patient reached the current position before or after medical treatment, isn't it better to distribute money according to medical needs, regardless of how they were created? The no-fault system might look attractive at first glance, but it suffers from prohibitive costs and might create new injustices which are no better than the old ones. So, if the current system needs reform, then we also need to look at reforming it in the other direction. Instead of shunning fault, perhaps we should put more emphasis on the question of whether or not the doctor was at fault. One way to shift more weight to the doctor's conduct is to move from tort claims to criminal offences. There may be other ways to do that, certainly, but the topic of today's lecture is the criminal law, so I shall focus on this, the criminal route, and I shall also assume that the attribution of fault has a more central role in criminal offences than it does in civil torts. Now, admittedly, this distinction between tort and criminal law might oversimplify matters about both areas of law, but for now I just would like to bracket these wider questions about the nature and purpose of each area of law. So an immediate objection to criminalization of doctor is that it seems grossly unfair to send to prison a person who had no intention of harming his patient, prosecuting the hand who tried to help you. He might have been reckless or grossly incompetent, but the appropriate sanction for such misconduct seems to be suspension rather than imprisonment. But what is the difference between convicting a grossly negligent doctor who has killed an innocent patient and convicting a grossly negligent train driver who has caused a train accident and killed an innocent passenger? Doctors are sometimes regarded as being on a different moral landscape because they are trying to help patients. But isn't train drivers trying to help people too, although to a smaller extent by taking them to wherever they want to go? Perhaps one might retort, we shouldn't convict either of them then. In this position, we should question why only professionals should be immune from criminal liability. What is the difference between a grossly negligent doctor and a grossly negligent car driver who caused an accident fatal to an incident pedestrian, if, say, both were talking on the mobile while operating or driving? Now, as noted by Professor Spencer, much of the intuitive objection to the conviction of doctors seems to rest upon deeper questions about the relation between negligence and guilt. One of the most challenging questions in the theory of criminal law is whether it is justified to blame a person who caused harm when she had no intention to do so. And the question becomes even more complicated when the various mental attitudes recognized in criminal law are taken into account. I personally am still puzzled by the blameworthiness of negligent conduct, and I have not yet found a persuasive theory to justify it in comparison to intended or reckless conduct. But my point is that it is hard to justify why only doctors should be exempt from criminal liability for gross negligence, whilst other professionals and the rest of the public are subject to a similar regime. Now, moving from civil claims to criminal offences could benefit the public, the patients, and even the doctors themselves. Let us start with the public. In the current system, it is the taxpayer who bears most of the consequences of the doctor's negligence. This happens for two reasons. First, the money for compensations end up being taken from the budget of the NHS Trust through a rather complicated system of voluntary membership in various schemes of the NHS Litigation Authority, a system which I want to detail here. In addition, the cost of insurance is also taken from the NHS budget. Again, the exact mechanism is not important. Since the number of claims, the cost of litigation, and the size of the average award are constantly rising, the insurance premium rises as well. To take one example, the premiums for GP trebled from around £1,000 to around £3,000 between the 90s and 2000. Traditionally, compensation was viewed not as a sanction, but as means of bringing the victim to the position he would have been had the doctoral conduct been lawful. However, even though we do not have punitive damages in this country, one cannot ignore the impact that seriously flawed conduct by a doctor is likely to have on the parties and on the judge. For example, the more flawed the doctoral conduct, the more difficult it would be for the NHS to quibble about the amount of compensation that the patient deserved. It is hard to accept that the level of compensation is completely isolated from the seriousness of doctors' misconduct. Now, moreover, there's again another issue of distributed justice here. Why should victims of clinical negligence receive more taxpayer money than other patients who didn't suffer negligent treatment? Or more taxpayer money than any other person who needs support from the state? Why shouldn't resources be allocated according to actual needs of patients rather than according to the existence or lack of fault? Moving to criminal offences would allow the courts to impose direct sanction on grossly negligent doctors and would take the pressure, would take the pressure off the monetary consequences of the misconduct. In addition, victims of clinical negligence would be brought into line with any other victims of criminal offence, which at the end of the day may reduce the amount of compensation. Not to zero, of course, since other victims of crime are entitled to some compensation under the Criminal Injustices Compensation Scheme. It also seems more just that the person who negligently caused the harm is the one who should bear its consequences. The criminal system could also have benefits from the victim's point of view. Against the public perception of opportunistic patients who just look for easy money, empirical research reveals a different picture. For example, a study of over 200 families in the UK who sued their doctor and were asked for the reason for litigating showed that while 87% sued to get an admission of negligence, only 55 specified financial compensation as their reason. Of course, people might lie or be shy of admitting their financial motivation, but given the difficulty and time it takes to obtain compensation, together with the emotional distress involved in reliving the event over and over, it is questionable whether the issue is really merely about money. Words such as accountability and responsibility are commonly used by those claiming compensation in this context, and these notions may be better catered for by a direct criminal sanction than a remote monetary compensation. The final consideration I will bring to notice may be somewhat surprising. That is, the benefits that the move to criminal liability could yield for doctors themselves. First, doctors would benefit from much higher evidential standards. In the current system, elements of the claim for negligence have to be proven on the balance of probabilities, where criminal offences require proof beyond reasonable doubt. Moreover, in the current system, there are cases where the court shifts the burden of proof to the defendant doctor, for example, in the proof of causation. Such reversals of burden of proof would be harder to make in criminal court. The doctor's right would be protected by the common law tradition, such as the presumption of innocence, and by Article 6 of the European Convention of Human Rights, what known as the Fair Trial Clause. Overall, the interest of doctors would be much more central to the process than they currently are, and the various mechanisms which protect the accused's rights would be at their disposal. In the current system, it is sometimes easier for the courts to find liability, because it is well known that the bill is going to be picked up by an organization with deeper pockets. This is particularly true in places where an insurance company pays the bill, but also when the organization itself is just large enough. For a judge, it may be quite troubling to send a miserable person who needs every penny home without any compensation whatsoever. It is probably a comforting thought to know that even if you give the victim compensation, it's not going to be paid by the doctor herself, nor will it mean any direct sanction on the doctor. In Israel, for example, a doctor was found liable for negligence in case involving brain damage as the result of simple injection during dental treatment. Liability was found even though the risk of such damage was virtually unknown at the time of the incident. The judges specifically referred to the deep pockets of the defendant insurance companies. The point of view of the dentist, who was actually a volunteer from North America, was almost forgotten. Moving from civil liabilities to criminal liability would mean that doctors would be found liable only when they were really guilty and not considered simply as a vehicle to allow the courts to give compensation to a needy victim. To conclude, of course, many of the considerations I've mentioned require more data and further argumentation. Arguing seriously for such a controversial position would require much more than the many minutes I have taken as a commentator. However, the point I would like to make is merely that there is a case to answer here. Moving from civil monetary claims to criminal offences is not necessarily a bad idea. And there are several weighty considerations which support such a move. One can be justifiably skeptical about the way in which the current government implements this idea, but flawed implementation doesn't mean flawed principles. While most of the scholarly debate today focuses on no-fault alternative to the court system, it seems that the criminal option has some potential to benefit the public, the patients, and the doctors themselves. Thank you very much.
Thank you very much, Amit. I believe Professor Spencer wanted to say a few words in response to what Amit just said, and then we shall have some time for questions until about 7 o'clock.
I'll be brief. That was stimulating and interesting, but I could hardly disagree more. I think about it this way. We've got a series of different things that we seek to achieve in legal regulation of health professionals. We've got, first of all, safeguarding the public by removing people who are dangerous or unfit to practice. Fault comes into that we will need to remove from practice the people who abuse their position by sexually assaulting their patients or whatever, but it's not determinant. You can get doctors who are just no good, and they may be doing their incompetent best, but we need to remove them. We need a mechanism to do that. I suppose that has to be the GMC. Then you have compensation. It seems to me fault of the doctor or otherwise is not something that should be determinant there. It would be far better if we could only find a means of providing some without fault compensation scheme. Punishing doctors isn't really what you're trying to do when you're compensating people who suffered from medical accidents, or shouldn't be to my mind. Then you've got punishing them. It seems to me there's a place for punishment, but only for the people who are very worse and whose behaviour is morally stigmatic in some way. And I think it's right that the criminal law is normally something which is regarded as a thing you try not to get involved with, and it's stigmatic to be involved with. One of the reasons Sir Peter Berger, a retired admiral, decided to retire early as our bursar from Selwyn College was when the health and safety legislation was changed in such a way that he was going to be strictly liable for everything, and he thought it just wasn't appropriate for somebody in his position to find himself as a defendant in a criminal court when he hadn't acted with any fault. And I've often thought of that when people talk about imposing strict liability. I think there's a place for punishment, but it should only be for the worst possible cases. And I think we have to keep separate the functions of safeguarding and compensating and punishing. Fourthly, there's something we haven't mentioned, which is prevention. What we really want to do is to have mechanisms which stop these things happening, and for that we need some system that ensures there are honest inquiries when there have been medical accidents. My suspicion is that damages claims for compensation don't help honest inquiries. They drive people into defensive positions, and I think prosecutions of the criminal court, where the stakes are higher, they have the same effect, only more so. So thank you for your response, but I don't agree with you.
So we have a good 15 or so minutes for questions. Does anyone?
John, I wonder if you could speculate on this concept of moral luck. It seems to me to be purely stochastic matter when someone's done something negligently, whether the victim dies or is merely injured. And so why is it that just because the victim has died, that the criminal law should take such a completely different view?
People have tried to think up justifications to that for many years. Some people who are honest in their approach to it, like Professor Andrew Ashworth, say basically you can't and it shouldn't. The trouble is, there's such a deep feeling in society that it's worse to have caused harm by some piece of negligence or intention than to have just done something that might have harmed somebody. And to that extent, the law just has to reflect basic feelings people have, rationally or otherwise. I've never been convinced that the law ought to create such extreme differences in the degree to which people are liable to punishment according to the accident of whether a death followed from what they did. And I think we have to recognise it to some extent, but I think we hugely overemphasise it in the work of living.
I very much liked your rant against society's confusion, in particularly deflecting the true cause onto an individual. I was rather surprised you didn't start ranting also about our risk-averse culture. I mean, do you think it's the anxiety about risk and our extreme desire to avoid risk that has deflected onto this extreme sort of particularity of punishment?
I've often thought that hyper concern about health and safety is a displacement activity for deep concerns about, for example, dreadful threats to the environment like climatic change, which we feel powerless against, so we want to hit at people for doing things which we can actually deal with. I think also, in fairness, health and safety legislation came along in response to dreadful things that used to happen when people had their limbs amputated in industrial accidents and they didn't get much compensation and they were just regarded as expendable. So to some extent it's an overreaction to what used to be a very bad situation. And I share your concern about it. Of course, we've got to remember that you never ask a barber if you need a haircut. I mean, insurers are always there to sell you insurance cover, or and always telling you that this, that, or the other might result in legal liability, so you better insure against it. What the courts say when they're dealing with negligence claims is very much more sensible than what people imagine the law to be very often. There was a piece of legislation called the Compensation Act 2006, section 1 of which says, in deciding whether somebody is civilly liable for damages, the court may take into account the effects upon desirable activities in society if liability were imposed. It was exactly what the House of Lords had said shortly before they must do when they're deciding whether behaviour is negligent. And I'm told the genesis for this legislation by a civil servant, not my daughter, I hasten to say, who told me about it, was that Jack Straw went to a Labour Party conference and said, we are going to do something about the compensation culture. And he then went back to the civil service and said, well, no, not Jack Straw, Faulkner made this statement. Something must be done about the compensation culture. And then he had his advisors tell him what the present law said. He said, well, that's fine. What are we going to do? Well, say the servants, civil servants, we don't need legislation. Answer, well, I've given a pledge, so we have to have it. So we have an Act of Parliament which actually says the courts may do what the House of Lords have always said they must do. So,
Professor King.
Well, thank you. I wanted to ask you to talk a bit more about compensation. I like very clear that there are three jobs: protection of the public, compensation for the victim, the relevant punishment of the person who may have inadvertently caused the problem. And then there's the idea that no one can possibly have a no-fault kind of way of paying compensation because it would be much too much. But my view is that part of compensation is really bad for society. I mean, say you've lost your daughter, is it really going to make it all right to give you some money? But if your daughter's been damaged, you want lots of to look after your daughter. So how does it pan out if it was possible to focus compensation where it was going to do something, and perhaps for the others, get the guy who inadvertently did it to cut their grass or something? Would there not be some other forms of compensation other than money, which I think is corrupting?
there's a piece of legislation called the NHS Redress Act 2006, which was designed to set up a kind of cut-price alternative compensation system to suing in the courts, under which, if you wanted to, you could go to a sort of improved version of the NHS complaints investigation body, and they would look into it, and you would then be offered a package which would include, where appropriate, not cash but services to try to remedy the situation. And everybody thought this was quite a good idea, and it only comes into force when the ministers make regulations. And since 2006, the minister hasn't made regulations, and it's just died. And nobody really knows why, except the government lost interest in it. So we could do it differently. To answer your question further, the law already reflects the difference that you describe, because large damages are awarded to people who need support and looking after, relatively small damages are awarded as moral compensation when people are killed. Initially, none were awarded at all, and newspapers said it's cheaper to kill than to maim, and we can't have that. So Lord Mackay, when he was Lord Chancellor, caused the law to be changed so that there could be small sums. People would say Scotsmanly miserly sums, awarded compensation close relatives when people have died. And so you don't get huge sums of money simply by reason of having lost somebody unless you were financially dependent. So that distinction is already recognised within the context of tort claims. I think I've talked around your question rather than answering it. I'm sorry.
So might it not be that we're increasing the standard of care required to lawfully perform certain activities rather than finding liability for lesser faults or no faults? Particularly, I mean, so we might, for example, be changing what counts as a fault in doctoring or driving, not finding liability for lesser faults in general. I mean, well, yeah, might that not be the explanation, or part of the explanation that's going on?
I'm not quite sure I understand the question. Are you saying because of the desire to compensate, the courts sometimes find negligence where there wasn't really any negligence in a moral sense?
No, I guess I'm just saying that it's not we're finding, for example, liability for pulling out without looking, despite that not being a fault, is that we're reclassifying that as a fault, as a moral fault. We now think that's a moral fault where we didn't use it. Because it's interesting that it's confined to certain activities, such as doctoring. We now, it would be consistent with thinking that we now expect higher standards from doctors and from drivers than we used to.
As regards doctors, the law always did say they were criminally liable for gross negligence. What's changed is the practice of prosecuting them, which has become much more frequent in recent years. It's not that there's been overtly any change in the level of care the law requires of them. In respect of drivers, it's been an offence to drive carelessly since the 1930s. What's happened is we've made an aggravated version of it with a heavy penalty applicable when you kill somebody. So it's not in principle the standard of care which is different, it's just the level of punishment which is inflicted on an unlucky breach of it. So I think the answer to your question is no. It's said in civil law, the courts, conscious of the fact that defendants are usually insured, sometimes lean towards finding fault where there wasn't anywhere in order to compensate. But I think that doesn't happen as much as we imagine. There were 2 or 3 resounding judgments from the Court of Appeal a couple of years ago saying, we're very sorry that this person was hurt, but really you can't say that the parent was negligent in this situation. So,
Thank you very much for an informative and amusing talk, much of which I agreed with, but some of which I had some worries about. If I can just state my background, I'm an obstetrician, now retired from clinical practice, and have 20 years experience in clinical negligence in the civil courts, about 1,000 cases, mostly dealing with high-value cases for babies brain damage at birth. There was an editorial recently in the British Journal of Obstetrics and Gynecology reviewing the intrapartum care, the management of labour, and especially the looking after the monitoring of fetus in labour. And the editor concluded quite rightly that over a 20-year period or so, there had been no change in the standard of care. It was still lamentably low, as it always had been. He quoted, I think it's the Joan Baez song, "When Will They Ever Learn?" And I think those of us who practice in clinical negligence will echo that. If I can pick you up on a couple of points. I very much liked your firearms and motor cars requiring to be managed without negligence. I would add the obstetric forceps to that, and I don't really see too much difference between them. You mentioned as well drunkenness. There is no rule, there is no level of alcohol under which a doctor may not, or above which a doctor may not practice. In 2 of my cases, the relatives were puzzled by the fact that the doctor concerned attended once in evening dress and once in morning dress. And the babies were mangled over the course of it. The implication, I think, is there. You mentioned rules as well. There is to make rules. It's all very well to legislate the rules on driving, but who can legislate the rules on medical practice? Indeed, when on a very rare occasion I've been asked to consider whether the accusation I'm making a criminal rather than civil, it's been quite difficult for me because the rules just aren't there. And finally, you mentioned that once an action starts in the civil courts, people tend to polarize and become defensive. I think that does occur in low-value claims where proportionality doesn't allow full discussion. But certainly for an academic exercise, there is nothing to beat a high-value claim, where experts will genuinely sort through the facts of the case, refer to every scrap of ancillary information they can get, and I think come to a good conclusion. So for high-value cases, I favour the civil system.
That's very interesting. I would like to, I'm alarmed to hear that the level of obstetric care hasn't risen over the last 25 years. What would be your recipe for raising it? Not prosecuting more doctors, would it? Or?
I think you and I might agree on that one. I think we are saddled with the National Health Service that was conceived in the 1940s and in no way can work in the 2000s. There has to be a new blueprint for the way the NHS works and for the way it's funded. And none of the political parties are willing to take.
So it comes down to one of the things I was saying in my lecture, which is that we're scapegoating individuals for a bad system.
Scapegoating them in terms of criminal litigation, well, whether, for example, those two morning dress and evening dress cases warrant criminal action for drunkenness, who knows? It's long ago. At present, I have another case where the gentleman concerned has skipped bail and left the country. Without wishing to nauseate this audience, pieces of the baby's brain were found in his lungs. In that case, the coroner requested that the police investigated, and yes, criminal charges were referred rightly, I think.
So do I think. I'm not saying, and I hope I didn't give you the impression that I thought that medical professionals should never be prosecuted for negligent behaviour. There is a case for prosecuting gross negligence as a moral fault. And I think we need a clearer definition of what that is, and I commend Marion McCall-Smith analysis of it. Though, with some reservation now, hearing what our last intervener said about there seemingly not being a corpus of accepted rules of what you should and shouldn't do governing areas of medical practice.
We do have some more questions, but I think we should finish here for those who are going on to dinner. But before we finish, I want to say thank you again to the Development Office at Hughes Hall for helping to organise this event. Thank you to mostly to Ali and to Professor Spencer for talks and discussion, which, I mean, it's been very entertaining, so we said, more importantly, it's been extremely provocative and informative, and has touched upon some extremely important issues, both in fact and principle. So, thank you very much.